Good afternoon. May it please this honorable court, Dion Webster Cox appearing on behalf of Mr. Harris. How are you, Your Honor?
We will see.
We're good. We're good.
Mr. Brown, or somebody from the PD's office, because I did not get a substitution. I got an appearance.
Oh, I've got a substitution right here.
Signed off on?
It is.
All right, then I don't need to address. I don't need to address the public defender's motion to withdraw. I'll consider that withdrawn given the substitution. I do have an appearance and I will sign off on the substitution.
Thank you.
Thank you. All right. What are we doing today?
So, Your Honor, we were going to, there's several options that my client.
Well, and I want you to know, counsel, that because of certain things, the court has a number of things I have to say. Okay. Because I think the record, given particularly some of Mr. Harris's comments with reference to this court potentially acting what at least as I'm to understand is on what some may be, or is it, let's put it this way. People are saying, and quite frankly, your client has made the assertion that the Pittsfield Township, as well as this court, was acting on some type of defective or faulty information, which I will tell you, counsel, caused the court, given what the court did, to investigate what my ruling was. And I will tell you that that assertion is absolutely correct with reference to any faulty information that either came through to the Pittsfield Township Department of Public Safety or to this court ultimately at the May 15th hearing. And I think it needs to be stated, I've been asked for comments. I have refrained from comments, as is my normal practice is. This court with the pending case will speak on the record. And so I am going to make sure that the record is very, very clear as to what this court knows and what this court acted on May 15th. And we can start with this. And my basis for doing it is because of what was said about what this whole process was. And that an indication, counsel, and I know, counsel, you've been before me before. Absolutely. I know it is not coming from you, but you also know how I am. I do. And the thing is that if for whatever reason, the one time in my life I was wrong, I will say it and did. But when I'm not wrong, and when people are not to blame, then it also needs to be said. So I will try to get through this as quick as I possibly can. But I will tell you, first of all, with any reference to your client having had a license on that day, and some indication or misunderstanding as to whether or not he had a license, let me make it very clear, based upon what the court looked at, he has never had a Michigan license, ever, and has never had a license in the other 49 states and commonwealths that form up this great union. He has never had a license. In point of fact, when they suspended his license, and what people don't understand, when they suspended his license in Saginaw, they don't suspend the license. They suspend the privilege to drive in this state. Hence, for example, if he had had a Kentucky license, he would be able to drive everywhere that Kentucky would allow him to drive. He just couldn't drive in Michigan because his privileges had been restricted. I know you know that, but that wasn't at all said. But it doesn't matter because he didn't have a license ever. There is also then, and you know, I will, when it is necessary, come to the defense of my sister courts, and I will come to the defense of Saginaw. They got a great chief judge. Chief judge answered the question. But I will tell you, that court and its friend of the court did nothing wrong. His license was his driving privileges, better stated, were unsuspended in 2022. That required Mr. Harris to do something. He didn't do it. Send anything to the Secretary of State. Now, I hated that I had to look at all of this, but when there's a question as to what I did, I'm going to look at everything to make sure that what I did was all in order. There's then an indication from that because that wasn't sent, there was a direct attack on Michigan's Department of Secretary of State's office, saying that the Secretary of State was somehow at fault. Let me tell you something. Secretary of State did what they were supposed to do. And in point of fact, they did nothing because they hadn't gotten anything from the court because Mr. Harris had not paid the reinstatement. This week, or the latter part of last week, once he paid that, Saginaw friend of the court did what they should do, and they sent it. Immediately, based upon the information that I have, the Secretary of State did what they do every day. They took that suspension off of his driving record, and he was then unsuspended. And then your client did what he needed to do with reference to the Secretary of State and paid a reinstatement. Okay. Just a second, Mr. Schiller. I'm going to let everybody respond because
Thank you.
I am not done yet.
Okay.
All right.
You covered a lot of the points for me. Thank you, Your Honor.
And so that came down to that. So the information at the time that I had, that Pittsfield Department of Public Safety had, was all correct at the time of both Pittsfield stop as well as the May 15th day. It was all correct. There was no error by anybody. It was a failure on the part of Mr. Harris to do certain things. Now, I grant you that sometimes that can be a complicated process, but it was certainly not anybody's fault that that didn't happen other than that wasn't paid. Now, here's the other thing, and I'm like maybe in church where I say I'm about finished now, but the other part of this is this stop was in October. Most of the cases that we've heard just in this last afternoon are driving while license suspended cases. That's part of my Wednesday afternoon. We go through great pains to try to get people their licenses back, which is really how it should happen. Between October and because I don't live under a rock, I actually watch things. You look very nice on TV.
Thank you.
You're welcome. There was something that was said that was very disturbing to me. And I'm just going to let you know because I believe in being fair with everybody. The question was asked along the lines between October of 2023 and the point in time of the May 15th hearing. Was there an attempt by Mr. Harris to correct his license? Here's the part that was disturbing for me, so that you know.
Okay.
Mr. Harris indicated that at some point he had been involved in some accident. And being involved into the accident that he was basically bedridden or at least housebound, he could not get to the Secretary of State. That was set up there. And I'm going to presume, because my knowledge of counsel, defense counsel is, I know you don't misrepresent anything.
Right.
You never do.
Right.
That's not true.
Okay.
He purposely stated that he could not get to the Secretary of State, which for the way we handle things in this court would have placed him in a whole different category. We would have tried to find a way, let's figure it out. And the reason I know that is because Mr. Harris, on December 28th of 2023, do you know where you were?
December 28th, 23.
23rd.
2023.
I know I was laid up from my
You were
accident.
at the Secretary of State's office. And you were at the Secretary of State's office because you redid and got your new Michigan ID. I have the date. That's the date you did it. December 28th, 2023. You did. And so that you also know, and in all fairness to counsel, because I don't know if counsel knows this or not, the way I know that he's never had a license is because May 3rd, 1990, he was 19 at the time. May 3rd, 1999, he applied for his first Michigan ID. Counsel knows, so I do, you cannot have both. You either have an ID or you have a license, one of the two. He has religiously every year gotten a new ID. And so he knows that he doesn't have a license. And quite frankly, I just wish he would have said that at the beginning. And all of this hoopla could have been just put all aside. And we all go through the process as we do with all of the people coming here to try to get him his license back. But his falsehoods, misstatements are not going to fare him well in this court. I'm done for now. I'm sure I will have something else to say. Whichever one of you would like to speak first, you may.
I'll wait to go last.
Yes, I spent yesterday at the Pittsfield Township Police Department with Officer Monaster, performing the traffic stop in this case. I also noticed the December 28th, 2023 date, and I know the significance of that, and the court just went through that painstakingly, and I thank you for that. In addition, at the traffic stop, when I was at the police department yesterday, we watched the body cam video. At least twice during this traffic stop, he acknowledged to the officer that he did not have a valid license. Quote unquote, quote, actually, I don't have a valid license, close quote. The question was, are you a valid driver? Quote, I am not, close quote. So, you know what, this is all this hoopla and the circus atmosphere is, in my opinion, is an affront to the justice system. I mean, I've been a prosecutor for more than 30 years, and to see this kind of hoopla around a driving while licensed suspended case is ridiculous. And it wasn't caused by this court. It wasn't caused by the Pittsfield Township Police Department. It was caused by the extra judicial statements made outside this courtroom.
Thank you.
Okay, so
Go ahead, counsel.
thank you, Your Honor. Thank you very much. Well, first thing I'd like to say is, very first thing is we're here and that we all saw this video. I wasn't in court. I wasn't even on YouTube watching the court today, right? I saw it because someone saw it and decided to post it. I can assure you that that was not Mr. I don't think he has the capacity to be able to post it like that on YouTube or Instagram. So that was not him. And it happened to take off and go viral. So he had what we saw should not have been driving, right? We're told not to drive on Zoom while doing that. So that's how this came to the attention, because the court, I saw you. He said, I can't believe this. Is he driving? And we all said that. Everyone who saw that video asked the same question. And that just became a joke. It became a complete joke. Now, with respect to what we want to do, and I cannot say anything is with respect to what my client has said, but when we talk about the hoopla, my client didn't start the hoopla. Perhaps he's made some comments, but he didn't start the hoopla whatsoever. That was someone that was outside of his control as to how it went viral. He had no control over that. And that I'm going to stand on that. He did not send it out to Instagram. He didn't send it out to wherever. He didn't do that part. So with respect to, did he have I don't want to try this case today at all, but what I want to do is focus on what's good. Now, what was good? That day in October, this officer here, that could have gone a whole other direction. And I'm so happy that you were so kind and courteous to my client. Thank you, officer. Thank you so much, because it could have gone another direction. We are here right now. My client has an appointment to go to the Secretary of State for his permit. He's working on that. I want to focus on how do we correct this and cure this? How do we go forward with this situation? Whatever, he was not under oath under any of the things that he said. So we're not talking about any type of perjury going on. Very true, right?
True.
So with that being the case, let's move forward with this. He is here. This is what I'd like. Because
Counsel, let me just.
yes,
I would like to move forward too
yes,
on this case. We handle these cases all the time. But I will tell you, as you know, having appeared before me, the one thing I don't like is when people don't take responsibility for what they've done. When they take responsibility for it, we will use whatever we can to try to get you to another spot, because it doesn't behoove any of us for you to be in that spot. One other thing that I will say, when you say it wasn't started by him, oh, it certainly was. It certainly was when he made his first statement to WXYZ about blaming people for this happening. And he shouldn't have done it, because when you look at the whole thing, the person that needed to be blamed, and we can go back to a lot of other points, but I'm not here to embarrass it, but the person that needed to be blamed is the person that he was staring at in the mirror. He didn't do what he should have done, and that's okay. The majority of people that come here on a licensing didn't do what they were supposed to do. That's like a given. They don't go about blaming anybody. They just say, Your Honor, I didn't pay the ticket. Your Honor, I just didn't do it. I just didn't have the time to do it. I just didn't take whatever.
right.
Just own it. Once you own it, then it becomes a whole lot easier just to move forward. Okay, I'm sorry. I interrupted you and I said I wouldn't, but
I understand.
my court.
I know who you are, and I respect that. So, and where I am is where I've always been, because I can assure you that when he did speak to WXYZ that day, I wasn't representing him. I was representing him yesterday, right? And you would heard my message is that what steps are to correct this, and that's what I'm about, Your Honor. How do we correct this, right? I understand the entire process. I have not gone into detail, but I will take the word of the court and of Mr. Stiller here, brother counsel, and about the background and the history of it. But how do we go forward? And that's why I'm here to sort of minimize. You okay? And he did get into an accident. May he sit down? Please, Your Honor. Right behind. Oh, well, hold on. Okay. And now that's real. That's a real injury.
I have no comment.
Okay. So what we're looking for, because there are some options here. My client has indicated to me and would like me to indicate to the court that he is in the process of procuring his license. Hopefully that privilege will be available to him, but he does have, as you stated earlier, and I have the receipts, he did pay the reinstatement fee. Those fees are paid. Anything that was out in the previous court, those fees have been paid, and I've been presented with those receipts. In addition, on tomorrow, he's got his permit test coming up, and then after that, because he's an adult, he's working on it so that he can take advantage of the offers that are available, because as you say, this court does want to help. Absolutely. And with that, because my client was in an accident, and I haven't seen the medical records, but because of some of the things it could be, I don't know. but sometimes our memories get a little foggy. Now, am I going back to 1999? No, I'm not. But I'm just saying that I'm saying from this day forward, he is working diligently to take the steps necessary to get his driver's license so he can take advantage of the generous offer. Thank you.
Yes, ma'am.
Yes.
Yes,
I
Mr.
hate to
Jones.
say this, John, one additional thing. I think Fletcher Cox and I need to approach the bench. It may involve Mr. Allen.
Who's Mr.
I
Allen?
know, because I know what it is.
Okay, thank you.
Well, who's Mr. Allen?
That's my bailiff.
Oh,
I will give out whatever date I can.
okay.
Counsel, you probably didn't know this, and I wasn't sure where the prosecutor was going to bring. He's got a warrant.
No, I did not know.
Yes, he has a warrant for his arrest. A bench warrant out of
Allen Park.
Allen Park.
24th District Court.
Okay.
The shocking thing about it, for a driving while license suspended, that he didn't take care of.
Okay. Well, like I said,
So-
he wants to handle.
So
He's
what it
dedicated.
is that, and it's a valid warrant, I happen to be within their radius of pickup. Now, having said that, I don't know if they will pick him up.
Okay.
I will say that what should have happened, I'm not going to go through and try to figure out whether it did happen. But when he was arrested, when he turned himself in on my revocation of bond, upon being released, he should have been apprised, warned, and released to go take care of it. I don't know whether he was. I really don't care whether he was or not. All I know is that was back at mid-May, and it hasn't been taken care of. And it's still valid. I was hoping maybe that somebody was going to try and take care of it, because I'm sure if you had known, they would have been done. So much so that part of my delay in getting out of here was to make sure that it was valid. I had my staff run him right before I came out, so that if it hadn't gotten taken care of and in, then fine, we were okay and I didn't need to deal with it.
Right.
But it's still there.
Okay.
So will July 17th work as a new date for you? Come back, because as I understand it, he is right now not licensed. So if he goes in on Thursday, gets his permit, he's got to drive for at least 30 days. Apparently he knows how to do that part. Sorry, that was, I'm sorry, I didn't need to say that, but he knows how to do that part, but then he's got to go back, take the test.
Right.
And then he can do that. He may be able to accomplish it in that time, that 45-day period. If not, I mean, counsel, I just want him to have a license.
We all want the same thing. One moment. So the 17th, it may not be me, it'll be another attorney from my office who can.
Well, I don't want
examine the
that.
trial.
I don't want that.
You want me?
Yeah,
Okay.
I know. You'll never hear me say that. But I don't want to go through this whole, you understand it.
Right. No, I get it. So I started trial on the 15th and
What's my date after the 17th?
August 7th.
What about August 7th? We can just put it out and then he can do what he's going to do or not do what he's going to do, but he should be able to.
August 7th at 1 o'clock, or would it be at 9 a.m.?
I will set it at 9. We will send an invite now that we have your appearance. So you'll get a direct invite from us as to what time about he's.
Okay. And then I just need one moment to talk to my client. You want to
Yes.
tell me something? Okay. August 7th at 9 a.m.
At 9 a.m. I'm going to take him into custody on the warrant. The only question that I have, and the way I look at the warrant, the bond looks like $500.
Okay.
Two things. First, I don't know whether or not they'll come get him. If
Right.
they don't come and get him, we'll
that will release him. We're not going to hold him. If they are coming to get him and he's going to be held, the only question I would have for you, counsel, is do you want me to set a nominal bond on this so that he gets credit, or do nothing and not worry about it? I'll leave that up to you.
Okay, that will be, but absolutely, I want him to be able to get full credit for anything that is necessary.
So let's do it this way. If he's not, so I'm going to take him in. If for whatever reason he's not released tomorrow, call my office, and with the agreement, I will set a nominal bond on it rather than do it right now. So he has to deal with two things. So that you're also clear. Part of the reason I'm also doing this is because I think he was warned and released, didn't take care of it. And secondly, this has been out there for 9 years.
Well, I did not know about it, Your Honor. Okay.
Counsel, there is not a doubt in my mind that that's true. Yeah, I no, you did not. I go to the bank on that one in a minute because I know you would have taken care of it.
Yes.
All right.
It's going to be taken care of today. His wife is here, and it will be taken care of. So I will absolutely call your office tomorrow to see call the court to see the status of it. Oh, we're going to take care of this.
All right.
Okay, that's what we're going to do.
We'll see you in August.
Okay.
Defendant is remanded on the Allen Park. Sorry.
In this chaotic and revealing courtroom session, two completely different cases collided to create one of the most unexpectedly dramatic hearings of the day. It began with Bobby Beach, who walked into court barely awake, confused, and immediately raising red flags. When the judge asked if he had used any controlled substances, Bobby proudly waved his cannabis card, insisting it gave him the right to medicate, completely missing the point that no one is allowed to appear before the court while under the influence. His confusion, slow responses, and even forgetting where to stand only added to the judge's concern. But the real eruption came when Bobby suddenly declared he wanted a new attorney, claiming poor communication, even though the judge described his current lawyer as one of the best in the entire county. The judge pushed back hard, reminding Bobby that not understanding the legal system doesn't mean the attorney is failing. It means Bobby needs to ask questions and listen carefully. With no evidence of incompetence, the judge denied the request for a new lawyer but granted a 1-week adjournment so Bobby could meet privately with counsel and sort out his confusion. The tone then shifted as the court moved to the second case involving Mr. Melton, whose matter centered on home confinement and community mental health services. His attorney requested more time due to ongoing plea negotiations. But things grew complicated when they asked the judge to approve home confinement based on an apartment supposedly arranged through a CH worker named Tom. The problem: no documents, no written verification, only verbal claims that someone has a key and everything was ready. The judge rejected the request, emphasizing that public safety and proper protocol require confirmed addresses, confirmed supervision, and confirmed readiness, not hearsay. Still, he left the door open, telling both sides to bring evidence and revisit the issue once they had concrete proof. This hearing perfectly captured the unpredictable tension of real courtrooms: a defendant who misunderstood his rights, a frustrated judge forced to teach courtroom basics, an attorney trying to maintain control, and another case hinging on documentation rather than emotion. It showed exactly how judges balance empathy with authority, patience with discipline, and fairness with legal responsibility. For more information, like and subscribe my channel.
Morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Beach, who is approaching. Mr. Beach,
Where?
state your name, please.
Yeah. Bobby Beach.
Your Honor, we're requesting an adjournment. Mr. Beach, I'm providing Mr. Beach a copy with discovery today. He wants to review it all before next.
Before I adjourn it, Mr. Beach, you had any controlled substance today? Mr. Allen? No. You've had nothing. So if I give you a test, you'll come back clean?
Well, this card right here tells me at your community corrections that I can smoke marijuana and I paid money for it. State of Michigan. Say right here, regulatory cannabis. I pay money, taxes. I should be able to medicate. I just had lower back surgery 2 years ago, St. Joe Hospital. They said either use prescription drugs or use what the state of Michigan provides you, the taxpayers.
Okay. Would that be the only thing that would show up in your system?
That's it, Your Honor. I know.
I'm going to pass the matter. I'm going to let him go on his own. Take a test, come back, and then I'll decide what I'm going to do. Despite your ability to use marijuana on that card, you can't be under the influence when you come into court. You understand that?
Yeah, I'm not now. I just woke up. I'm not now.
Oh, you just woke up?
Yeah,
That's why you
sure.
didn't know where to go in the courtroom?
Yeah, I just had a
Yeah,
daughter.
okay. No, I got you.
I've been babysitting her
Okay,
this
yeah.
morning. I just
Okay,
woke up.
I'm hearing you. I'm going to trust you to go over on your own. Let's see what the test is.
I'm not smoking coming on court, Your Honor.
Really?
Yeah. I'm not.
Okay, all right.
I'm very
Okay.
coherent.
Okay,
I'm
all right.
pretty-
Then you probably ought to stop talking and go take your test.
Okay.
All right? Yeah, that way. You better, yeah, get an order over to him.
Just a one time.
Mr. Feaster, tell Miss Perrin he better point the way because he's going to get lost.
Can I address the court, Your Honor?
I'd advise against it. I've advised him to speak to me first.
You want to address the court, your counsel has advised you that it may not be possible for you to do so, so.
I and my attorney don't see things the same way. So I would, right now, like opportunity to get another attorney.
Okay, and how do you intend upon doing that?
I beg your pardon? I'm hard of hearing.
Can you hear me now?
Yes, sir.
So with reference to an attorney, how are you intending upon doing that?
I'm going to ask to have another one appointed to me.
Well, it doesn't quite work that way.
Okay.
And this is news to me. I did see Mr. Edwards yesterday, and there seemed to be no issue.
So you've actually talked to Mr. Brown?
In this whole procedure, I may have talked to Mr. Brown, what, maybe about an hour, 15 minutes here, 15 minutes there, 5 minutes here and 5 minutes there.
Okay.
This is my first time ever being in court in any type of way.
Okay. So what am I supposed to take from you?
That I'm not satisfied with my attorney. And I think I should have.
So what are you not satisfied with?
Our communication, my understanding of anything.
Have you been listening to him?
Yes, I have.
You have?
I've been listening to him.
And you're telling me Mr. Brown hasn't properly communicated to you or with you? Because if you're going to say that, I don't believe it for a minute. He's one of the finest attorneys Washtenaw County has. So you can go ahead and say what you want, but I'm letting you know the perspective I'm coming from.
No disrespect to Mr. Brown.
Well, you're about to then. Go ahead.
Yeah, that's exactly what I'm saying.
Really?
That I don't understand.
Okay, you not understanding doesn't mean that the attorney isn't doing their job. I don't see a basis upon which to take Mr. Brown off this case. You can go ahead and hire your own attorney.
Okay, that'll be the next procedure that I'll try to do then.
So you're going to try to hire your attorney. How much time you need to do that?
I'm not sure, sir. I don't know.
Well, I got to set a date. How much time do you need? You don't like the best that Washtenaw County may have to offer, and now you want to hire somebody else. How much time do you need?
Well, first of all, I got to try to come up with some money.
Oh,
Then second of all, I have to have someone to help me find an attorney.
Mm-hmm.
Is it a such thing as a promo attorney?
A what?
I may not be pronouncing that correctly, but I'm a lot of judicial work done.
Pro bono.
Pro bono attorney, yes.
A pro bono attorney.
Yes.
Meaning one that is a good attorney that you're not paying for?
Yeah, yeah.
That's what you want?
Basically, that's what I'm saying. Yeah.
Okay, so you realize standing next to you is one of the best that you're not paying for right now. Yeah, no. I'm shocked.
I wouldn't challenge that. I wouldn't challenge that.
You would?
I wouldn't challenge that. I'm not saying he's not. I'm just saying.
oh, so now you're not saying he's not.
I've said what I've said.
Mm-hmm.
And
So to the extent that is even a proper motion to permit withdrawal of the public defender's office and Mr. Brown, that motion's denied. I don't see a basis upon which to do it.
So, Your Honor, what I'm going to ask to do is to adjourn this for 1 week. So that,
1 week?
yeah, so that my client and I can have a chance to talk and find out the nature of his discontent.
Probable cause conference will be adjourned. 1 week has what, the 6th? June 6th, 2024. 9 a.m. as your invite indicates, bond will continue. All right, Mr. Edwards, I'm going to make a suggestion to you before you take those off. I'm going to make a suggestion to you.
yes, sir.
Rather than doing a whole lot of thinking yourself, when Mr. Brown comes and talks to you, maybe you ought to listen to him. And then if you have questions and you may not understand something he's saying, you should probably just ask it. And then you'd have probably a better understanding of what's going on, and we don't have to go through this again. Thank you. Have a great day.
No, can you please state your name for the record?
Franklin Joseph Melton.
Okay.
Your Honor, we are asking for an adjournment in this matter as well. The adjournment is as a result of we sent a request for consideration for an offer to the prosecutor. We did initiate the negotiations. We're just still working on those. So I think a short adjournment would do it. Yeah, if the court so allows.
Oh, are you done?
Yes.
Any response from the people? Probable cause conference, June 13, 2024, 9 a.m. Bond continued.
Your Honor, if I may briefly.
That's where we were going. Go ahead.
I know. It's my understanding that Mr. Melton has CMH Act services set up. Tom Kloss is the individual who's assigned to the case to his matter. He has a set of keys and knows where Mr. Melton's going to be staying. Should he get out, an offer requesting home confinement was also sent to the prosecutor for her consideration as well to see about a stipulation to the request. And so I would just be asking for your consideration as well. It's my understanding that Ms. Tenha is leaving it to the discretion of the court.
Where would he be?
Up on Gulf side. I have a 2-bedroom up there, sir. Tom from Community Mental Health has the key and is ready for everything for home.
When did that happen?
I'd have to pull up the.
Well, no, when.
I'm sorry.
That's not the address that we have.
I think, Your Honor, that might be the address he set up with Mr. Kloss. I don't know what address that he may have given for arraignment purposes. And I'm certain that that was likely different. Is that correct?
Yeah.
Okay.
Yeah, that was a different one. The person's unable to do anything, but Tom Klaus has the key and has everything ready for home confinement.
So, my understanding, and maybe Mr. Brown, you can correct me if I'm wrong, this is my understanding speaking with him this morning, that this individual from CMH has confirmed that he has an apartment with a key for Mr. Melton. And that if he were to be allowed home confinement, that's where he would go. CMH not only would have any documents, I'm relying on representation by Mr. Bellinger that he has that information.
Why did you get a different address? Oh, because I thought the person might be able to let me stay.
Okay. Understood. Your Honor, to clarify further, during the arraignment, he gave a different address to an individual who he assumed would allow him to stay and reside with that individual. That address that he's now given to Mr. Klaas for purposes of home confinement is an address that he's had for a place that he's had for a year now. So it's his own place.
Yeah, and
On golf side,
I'm sorry,
On golf
side, sir.
he's had that for a year.
He's had his own residence for a year. I don't know what the circumstances were at arraignment to the extent that he couldn't go back there or why he.
What is the Arbondale address?
The Arbondale is where I used to live. I lived there for, I had the address for 22 years. Never missed rent.
Did this get you? Did being in custody get you evicted from that location?
No. We were already to golf side.
Okay.
We were already getting out of there.
Who is we?
Tom Klaus was and we were moving out of there.
So was Tom helping you do that through CMH?
Through CMH,
Okay.
yeah. It gets into this whole thing that it does, yeah.
Your Honor, if I may, just briefly.
Yes, please.
So what we would want for Mr. Melton is to receive CMH service.
Yes, correct.
If he's able to do so in a way that keeps the community safe and keeps him out of trouble, we are all for that. We understand that we always want to strive for the least restrictive means we can do that. If there is a CMH person who has indicated to Mr. Bellinger that he has a key and everything is set up for home confinement, we will leave it to the court's discretion. What I failed to ask Mr. Bellinger, and I apologize, is whether he's had direct contact with the CMH person, or if this is all relying on Mr. Melton's explanation, because there obviously have been some issues with that in the past. So if we can kind of clarify on the record that Mr. Bellinger has been in direct contact with Mr. Klaus with CMH and has received information from him that Mr. Klaus has a key to an apartment that is ready, that would be appropriate for home confinement. We will leave it to the court's discretion.
Your Honor, it's my understanding that Ms. Baltima from our, the social worker from our office has had and been working with him and has had that direct contact. I have not personally had the direct contact, however, someone from my office has.
Okay, so here's what I'm going to suggest. I'm going to, at this time, deny your request.
Okay.
However, I'd suggest that you work with the prosecutor's office, get that information to them. You've heard their position.
Certainly.
I think that's an appropriate position, that if there's some place that's safe that is appropriate for home confinement, that's fine. But right now, I don't have anything concrete that says he has an apartment on Gulf Side, and there's a lot of them there.
In one of the most detailed and revealing hearings this courtroom has seen, the judge took center stage to address not just the legal charge against Mr. Harris driving while license suspended, but the misinformation storm that erupted after his viral Zoom video and subsequent media interviews. The judge began by directly correcting the public narrative, making it unequivocally clear that Mr. Harris has never held a valid Michigan driver's license, not once in his life, nor in any other state, and that the only thing Michigan ever suspended was his privilege to drive within the state, not a physical license. She further explained that in 2022, when his driving privileges were restored by another court, Mr. Harris failed to complete the final required step, paying the reinstatement fee to the Secretary of State. That omission meant no reinstatement could be processed, and nothing about the traffic stop or the May 15th ruling was based on faulty information, despite his public claims to the contrary. Matters worsened when the judge revealed that Harris had falsely implied he was bedridden and unable to travel after an accident, even though official records showed he visited the Secretary of State in December 2023 to renew his state idea contradictory action proving he was capable of handling his affairs. The prosecutor reinforced this by noting Harris admitted during the traffic stop that he had no valid license and was not a legal driver, further undermining his attempts to shift blame. Instead of punishing him harshly, the judge emphasized that the real issue was not the violation itself, but the repeated refusal to accept responsibility, which turned a routine DWLS case into a public spectacle. His new attorney acknowledged that the viral clip was spread by outsiders, not Harris himself, but urged the court to focus on the present, where Harris has now paid reinstatement fees, scheduled a permit test, and is finally attempting to correct years of neglect. The judge agreed to give him time, setting the next hearing for August 7th. But the session took another dramatic twist when it was discovered that Harris had a 9-year-old outstanding bench warrant from Allen Park for another driving offense. The judge ordered him into custody immediately, explaining that if Allen Park did not pick him up, he would be released, and if they did, his attorney could request a nominal bond to ensure he receives proper credit. Despite the tension, the judge ended by reaffirming that the court wants him to succeed, to obtain a legal license, and to finally take ownership of his obligations. This hearing was not just about driving, it was about truth, accountability, and the consequences of letting misinformation overshadow responsibility. For more information, like and subscribe my channel.